Okay, good afternoon, everyone. We may have a few more people joining us, but we're going to go ahead and get started since I see we're just past 1 o'clock. My name is Allison Bronco Tisci. I am the manager of membership services for the Connecticut Community Nonprofit Alliance, or the Alliance, as we are more commonly known. It's my pleasure to welcome you this afternoon to today's Insurance Roundtable. In my position at the Alliance, I oversee both our membership services and our training and professional development program, which today's class falls under. Please reach out to me at any time if you'd like to find out more about becoming a member, or if you're interested in finding out more about your membership benefits if you are already a member. I'm also always looking for suggestions for future training programs. So if you have things that you or your colleagues would find useful and would like to see us offer trainings on those topics, please feel free to drop me a note in the chat today, or you can reach out to me by email with those suggestions. I also help to plan our annual conference, and we will be sending out a save the date email shortly with some more information about the conference and sponsorship opportunities. But since we're all on the call today, I'll let you know that this year's event will be on Wednesday, December 6th. We'll be back at the Connecticut Convention Center in Hartford, and we'd love for you all to join us then. I did also want to let you know that we are recording today's session, so that recording will be sent out to all of you with the slides from today's presentation. And we have allotted some time at the end of today's session for Q&A. So if you brought questions with you, fantastic. If you think of questions as we get going, there will be plenty of time for us to address those. So the title of today's session is How Insurance Can Protect Your Organization and Your Personal Assets. We're very pleased to welcome Chris Devaney, who is Vice President at United States Liability Insurance, which is a Berkshire Hathaway company, and Darren Bernesky, who is the Executive Vice President at Brown & Brown Insurance. Brown & Brown Insurance is one of the newest members of our Alliance Allies program, so we're very pleased to welcome them as a gold member. This program connects the Alliance members with businesses that specialize in working with nonprofits. So through this Alliance Allies program, if you are one of our members, you have access not only to the expertise of our allies, but also to special discounts on their goods and services that are made possible because of the buying power that comes with being part of the Alliance. Brown & Brown is the 5th largest independent insurance brokerage in the nation, and they have more than 80 years of experience, so they are one of the industry's most influential leaders. Following today's presentation, you can always reach out to Darren and his team for future insurance guidance. And we encourage you to consider them a resource if you have questions about insurance going forward. So I will put Darren's email and phone in the chat. And please feel free to reach out to him following today's presentation. And with that, I will pass you off to Darren. Take it away.
Allison, thank you very much. Thank you, everybody, for being a part of this presentation today. I think it's very important and pertinent today with what's going on in the current society, especially regarding nonprofits. One of our missions here at Brown & Brown is to provide education to both our for-profit and nonprofit organizations. So I'm very happy to be part of your group and present along with Chris today. And just overall, nonprofit organizations, they can be the lifeblood of many communities, providing valuable services to its community it serves. However, nonprofits are not immune to claims. So what I see as trends in our society today is that we're becoming increasingly litigious, and education and understanding those risks are important. So at this point, I'd like to turn the presentation over to Chris Devaney, one of our carrier partners at USLI. He's here to talk to you about insurance products to help protect your organizations. Thank you very much. And at this point, I'll let you take it over, Chris.
Darren, thank you so much. And Allison and Liz, thank you for the introduction. And thanks to everybody for joining and taking a few minutes this afternoon. I think Darren hit the nail on the head that, in today's society, the litigious nature is just, exponentially increasing, and nonprofits are most certainly not immune to some of the things that we're seeing. So my goal for today, was simply to provide you all with a little more information about directors and officers and employment practices liability insurance. Management liability insurance is another term we use for that in the industry. And just share with you some trends that we're seeing, some common misconceptions that people have. I'm going to share a few real life claims examples that I think really help bring to life, how this type of insurance can come into play for you as nonprofit professionals. And also, most importantly, how you can protect not only your organization, but your own personal assets. So you're not putting yourself at risk by making that choice to serve, by making that choice to be out in your community. So we'll kind of jump through today. So a brief outline of what we're looking at. I'm going to give you a little background on USLI, who we are, a little bit of an overview of the product itself, get into a couple, 2 truths and a lie, your common misconceptions, and a few claims examples as well. But as we said, if you have questions as I'm speaking, if you have questions about content that I'm discussing, please do, jump in with those at the end. We want this time to be valuable for you, and I'm be more than happy to stick around and answer any questions that you might have, as we go through there. So a little background on USLI. We are a wholly owned subsidiary of Berkshire Hathaway. So United States Liability Insurance Group actually consists of 3 underwriting companies: United States Liability, Mount Vernon Fire, and US Underwriters. So you may see, depending on the states where we're writing, any of those companies, they all tie back into USLI. We are proud to have an A++ rating, which is a rating given by a company called AM Best that just signifies the financial strength and stability of an insurance company. And that's a rating we've held for a number of years, and we're very, very proud of that. I think what we're most proud of, as we're talking today, is, we serve over 100,000 nonprofit policyholders across our team. So this is a huge vertical for us as an insurance company. This was an area that we've been very deeply involved in for the past several decades. And it's a big part of who we are, not only from an insurance standpoint, but what we do within our communities, within our branch offices and the surrounding communities there. We really do try to put our money where our mouth is and make sure that we're making an impact similarly to all of our clients who are doing wonderful things. So we've been focusing in this sector since about 1994. I'm going to talk today mainly about the directors and officers and management liability components. But I do just want to say we do write package lines as well, up to 9 different lines of commercial coverage, pretty much everything except for commercial auto and workers' compensation. But Darren and his team most certainly have markets for all of your needs, just giving you a little bit of a snapshot of what we're looking at from a USLI standpoint today. So when we talk management liability, I think in the insurance world, a lot of people, they really get property insurance, right? You have a hailstorm, it damages your roof, you're going to go get coverage for that. They're familiar with personal lines, auto, homeowners, even general liability, right? Somebody slips and falls, somebody gets hurt, but a lot of people really don't fully understand the magnitude of the management liability world, of the directors and officers world. And if you think about it from a nonprofit setting, a lot of the people involved on the boards are what? They're volunteers, they're community members, they're parents, they're coaches, and they are asked to sign up to do something, to serve on a board, to volunteer, whatever it might be, and they might not fully understand that they could potentially be putting themselves at financial risk by doing so. That's what D&O serves to do. It serves to fill that gap. It serves to protect not only your organization's assets, but your own. And it's usually bundled with these 3 main coverage parts: directors and officers, employment practices, and fiduciary. So the directors and officers world is really an all-encompassing coverage for all the decisions that you're making as a board member, as an executive director, whatever your role is within the nonprofit organization. So you're going to have your meetings every so often, and you're going to make a number of decisions. What do we do with, financial? How are we going to get fundraising? How are we going to spend the donations that came in? How are we going to best execute on our mission as we look forward 12, 24, 36 months down the road, right? And every time a decision is made in that room, it's potentially creating liability for claims where people may be impacted by that on the other end. And I'll talk a little more about that in a moment. I'm not going to get too far into the nitty gritty coverage because we do want to keep everyone awake throughout the presentation. I usually save those for the later nighttime hours, but do want to touch very briefly that within the D&O coverage part, you're typically going to have what are called 3 sides or insuring agreements, A, B, and C. So think of it very simply, side A, side B, side C. The way that typically breaks out is side C is a lawsuit where the organization is named in the suit. I'm suing XYZ Humane Society for misappropriating the donation I gave to the Humane Society. Okay. Side B is typically an individual officer is named in the lawsuit, but the organization is indemnifying them or paying them back or covering them for the damages associated with that lawsuit. Most nonprofits are going to have some sort of indemnification agreement within their bylaws where they say by serving, we are going to, cover you or pick up the tab should you be found liable for your service. Now, the problem is what happens when they can't? And this is usually, a compounded situation, but a side A claim is when an individual director or officer is named in the lawsuit, but the organization is unable to indemnify them or pay them back. These are the types of claims where your personal assets could potentially be at stake. The reasons that usually occurs is primarily driven by financial insolvency or a bankruptcy type of situation where the organization may not have the assets to pick up that claim. There are some other situations where it could come into play as well. But the end of the day, the message I want you all to walk away from here is side A from a D&O standpoint is your worst case scenario as a board member. Now, all D&O policies are going to address this in some way, shape, or form. I'll talk a little bit more about that further in the presentation. The employment practices coverage part, this is all of your dealings with employees, volunteers, which many of you probably have a lot of, and independent contractors as well. So, this could be your standard wrongful termination type of claim. This could be a race discrimination claim, a gender discrimination claim, an age discrimination claim. This could also be sexual harassment, workplace bullying. I actually saw an article the other day that New York, I believe New York State, could have possibly just been the city, recently passed a law that is now going to introduce weight as a protected class for employees. So they're expecting that there's now going to be some lawsuits increasing there, where if an employee feels that they were somehow discriminated against because of their weight, they can now file a suit. And those classes can change depending on even the city that you're located in, certainly the state, and then there's certainly federally protected classes as well. I'll talk a little more about the employment practices in a moment as well. And the third one today is the fiduciary liability, which is really a coverage part dealing with your oversight of employee benefit plans, retirement plans, things like a 401k, other retirement plan options, group health benefits, and the like. So we'll start with the directors and officers a little further. Part of the underlying things that come into play here is something called a fiduciary duty. And it's something that a lot of board members understand. And unfortunately, someone went and named a whole coverage, fiduciary coverage, which is really a different thing, right? So fiduciary duty is really just a standard of care. You have a high standard where you have to take certain steps and act in a certain way, as your responsibility for signing up for a board member, right? Or signing up to be a board member, excuse me. Stakeholders are going to be anybody who can be impacted by what you're doing. And that picture can change significantly depending on what type of organization you are and what type of organization you're running. I always use public and private schools as a great example. If you have a small, not-for-profit private school, and they're going to have a certain audience, which is going to consist of what? It's going to consist of their students. It's going to consist of the teachers, maybe the parents, and maybe the alumni. That's pretty much who you're dealing with in that context. If you move that same ball over into a public school, now who are you adding? Every taxpayer in that area or municipality, every homeowner in that area who are going to be financially impacted by the performance of that school district. Nonprofit D&O insurance, very similar dynamic. The more people are watching you, the larger your scope, the more people you're reaching, the more potential stakeholders could be your claimants in the event that something goes south. Now, that doesn't mean a smaller organization has no exposure. It's actually the contrary, but it certainly does increase your numbers, right? And it's the numbers game that really comes into play when you have a much larger audience. So who else could these stakeholders be, right? You probably thought of a few of them. I mentioned several. Shareholders would be more in a private company context, but in the nonprofit world, I would say that's donors, right? Employees, customers, and clients. I've seen claims from competing nonprofit organizations, government regulators. If you're an organization that receives state funds, federal funds, a lot of nonprofits have received funding under the CARES Act or other relief funds over the past few years, and there could be a day where, that's audited or looked into a little further, or it could just be with standard grants and other things that you're receiving in the natural flow of doing business. Members, we do write a lot of, more membership clubs and things like that, in addition to the community support nonprofits that we write. So that's typically more of like your third party discrimination claim. Somebody wants to join a country club or a fraternal club or a cultural club, and they're not allowed to join for whatever reason. And then of course, somebody in the corporation or the corporation itself in what would be called a derivative claim, which is typically when you have one or a few numbers of bad actors kind of spoiling it for the group, where the rest of the group is suing for change. They're suing to make those people stop what they're doing that could be damaging the organization. So it's a very, it's a very difficult thing, even for folks like Darren and myself who are in insurance and thinking about this every day. It's difficult to always see where that claim could come from. And that's kind of the scary thing about D&O. If you're an attorney and you provide legal services to somebody, the person who's going to sue you is going to be who? Your client who wasn't happy with the result. In the D&O world, it can come from so many different angles. It can be very, very difficult to identify that in advance. So that's why I just feel that D&O is very, very important, because a lot of nonprofits may think, oh, we're small, we're a community-based group, we're all volunteers, we don't have a lot of money, who could possibly get upset with us? We're just trying to help out, right? Until something happens, until there's a behavioral conflict, until there's a personal conflict. These things happen, and sadly, they can be very, very expensive to litigate and to settle. Just a little bit more of the background of these fiduciary duties. You'll see kind of the four big segments there. Care, I call this the reasonable person test. It's what a lot of people call it. I did not make that up. But very simply, do your job. You have to show up for board meetings. You can't say, I wasn't at that meeting when that decision was made, I'm not liable. That's not going to fly. You had a duty to be aware of what was happening. You had a duty to be informed and to be educated. And you need to act as a reasonable person would have acted in that same instance. Loyalty is a tough one that comes up from time to time. These are usually more your bad actor type of claims, where somebody might be, financially benefiting from their position on the board. That's not very frequent, fortunately. I think 99% plus of the organizations we see are most certainly doing things the right way. There are unfortunately folks out there who tend to take it as an opportunity to profit, whether that's personally or in other ways, through their status on a particular board. Obedience is simply following the bylaws. I'm going to talk about a claim in a little bit where a very seemingly minor violation of the bylaws led to a pretty serious claim. And then regulatory, I kind of spoke about already in terms of, organizations that are subject to that type of oversight. largely because they may be receiving grant funds from those types of organizations. So what this protection is doing, and I'm going to talk a little bit more about this in a minute, but a lot of, folks can maybe not quite picture the lawsuit coming. And even if they can, may not view it as something that could be a large damage type of claim, right? In the nonprofit world, a huge portion of what this insurance is going to end up paying for you are defense costs, legal costs, and just navigating that world. There are private equity firms right now who have banded together to fund insurance litigation operations, where they actively go out and they target litigation, whether it's, primarily it could be for personal injury type claims. We're starting to see it in the management liability world, in the employment practices world. And essentially what they're doing is they're investing money into law firms that are set up to target high dollar litigation, high dollar claims, where they can then take a third of the profits or whatever they receive from the insurance company and return that to their investors. It's getting very, very sophisticated. There's a lot of sharing of tactics within those worlds, where if one case yields a very high verdict, that information is being shared, with other firms. And it's a real thing. It's happening. They're advertising, for clients. And that's in addition to what Darren spoke about at the beginning, which is just the general societal increase in litigiousness. It's the way things have been. The past 5 years have been really, really challenging. A lot of people lost their jobs temporarily or permanently. A lot of people have started new jobs. A lot of people have left jobs and gone to organizations, only to find out it may not have been what they thought it would be. Fundraising's been a challenge. I'm sure many of you can attest to that, especially for organizations that might rely on certain types of income. Think about a community theater, right? Summer camps, festivals, and things like that had a very hard time over the past 4 years generating revenue in the first place. And then you compound these societal factors on top of it, it can be very, very challenging. And even if it's an unintentional wrongful act, even if you don't intend to breach your duty, you try to do all the right things, you try to say all the right things, you try to treat people as respectfully as possible, it's not going to stop them from filing that suit. And even if you're not liable at the end of the day, attorneys are $400 an hour and up. And that adds up very, very quickly. And for the price of these policies, it's an absolute no-brainer for an organization. The employment practices side of things, believe it or not, we actually see more claims from employment practices with nonprofits than we do with D&O. Usually the D&O related claims are higher value. They are much more likely to reach the 6-7 figures. Employment practices is starting to creep up there. But just from a sheer numbers standpoint, employment practices are typically providing the majority of the claims that we're seeing. So this could be from your current employees, it could be from past employees who were let go, it could be from job applicants themselves, right? It could be somebody applying for a job who didn't get the job, dealing with all of the counts that you're seeing here on the screen. I think most of them, you're probably familiar with the term. Wage and hour violations is one that I do want to touch on. It's a big deal for the nonprofit sector specifically, as well as the restaurant and hospitality world. But wage and hour violations deal with the payment of overtime to hourly employees. So if you are what's called a non-exempt employee, which is typically your hourly employees who are not supervisors, they are entitled by federal law that once they go over 40 hours a week to be paid time and a half. Now, a lot of organizations, A, might not be as familiar with that law, B, might not have a great system in place to track that as exactly, as they might need to. Or, I've seen cases where an employer might quasi-knowingly violate that, and the employee's fine with it because, especially in the nonprofit world, they're working on something that they're probably passionate about, or that they probably, feel compelled to put that energy into, and it's all fine while everything's good. But then when something happens and that relationship becomes fractured, there can be leftover liability from that world. So these lawsuits are typically going to be seeking back wages, often for a long period of time. Think about if you were putting in 60-hour weeks for 5 years and you never received that time and a half payment, those dollars can really, really, really add up. Those can be expensive claims, especially when you're dealing with multiple employee situation, but they can be costly to navigate. And usually these insurance policies are going to have some sort of sublimit for those claims, whether that's for defense costs, for indemnity or loss payments, or for both. The soaring cost of litigation we touched on. One other thing I just want to add to that is we've started to see attorneys employ a tactic called time limit demands, where essentially they will receive a potential suit, and in the very early stages of the lawsuit, they will demand the insurance policy limits. As the nonprofit organization, as the board, as the leaders of that group, you have the final say into whether we as the insurance company will settle that claim. You ultimately have that consent needed. A lot of times early on, we don't even have all the facts. You might not even have all the facts. It might seem like the claim's not worth much, but essentially what some of these firms are doing are demanding the policy limits up front, crossing their fingers and hoping that liability is found down the road if that demand is not met, at which point they are then, employing something called suing for bad faith, essentially saying that you and your insurance company refuse to settle this for the policy limit. Therefore, we're now seeking more than your policy limit. We now want 4 times that, 5 times that, 6 times that. It works to varying extents in varying jurisdictions. But again, as Darren alluded to, the cost of litigation is rising exponentially, and it has no signs of getting lower anytime soon, which is why the defense cost component of these policies is so very important. The expanding interpretation of laws and protected classes, I talked a little earlier about New York adding weight to that list. A lot of municipalities have gone even further and added, broad ranging lists of things that would be considered a protected class under employment law. Our policies were pretty broadly worded in the sense that it will cover anything that's considered to be a protected class by whatever venue we're looking at, whether it's local, whether it's state, whether it's federal. But I think the third bullet point is really the most important here, is the increasing of employee awareness. 30 or 40 years ago, I was a child, but I don't know if a lot of people really even knew as much as they do today about workers' rights, right? About employees' rights. Everybody has the posters, hopefully, in the break room or somewhere within the premises, but who actually reads them, right? Who actually knows what these laws mean and say? And I think, with the internet and social media and these claims being so much more frequent and so much prevalent with so many big dollar values tied to them, people have a much more heightened awareness that this exists. And it may not just be the attorney trying to find them. They might already know that we're now seeking and going to find, legal representation ourselves. And we do tend to see that if an organization has had one employment practices claim, they are more likely to have another. Now, that might be a combination of issues with management, but it also might be other employees seeing that claim, seeing that person was able to get some money, and then filing, suit in turn so they themselves can get some. Fiduciary liability is the last one. I'm not going to spend quite as much time here. A lot of nonprofit organizations may not even have plans depending on their size. Certainly the larger and even, you know, medium-sized ones do, but your very, very small volunteer groups typically do not. Again, this is different than your fiduciary duty. Your fiduciary duty as a board member is just your standard of care that's established, you know, when you sign up to serve on the board, right? That's what your D&O is covering. Your failure to complete that duty or not. Fiduciary liability coverage is dealing specifically with your potential negligence in the oversight / administration of employee benefit plans. So that could be remitting funds into the retirement plans. It could be explaining the functions to them. It could be negligence in screening the vendors that you might be using for them. It's typically a relatively inexpensive coverage. It starts, you know, as low as $100, usually a few $100s, depending on how much money is in the plan. But under ERISA, which is the federal statute that governs these plans, plan fiduciaries can be held personally liable, you know, for their negligence or for their wrongful acts associated with that role. So again, if your organization, you know, does offer these types of plans to employees, even if it's a relatively simple plan, you know, for a couple $100, it certainly makes sense to button up that area as well. So the 2 truths and a lie portion. I had to pay extra for these signs. It came out perfectly. I just wish I had 2 truth signs. We'd be in good shape. So first one, this is a big misconception I hear from a lot of folks within the nonprofit world, is that charitable immunity laws provide protection to individuals who serve on the boards from being sued. Now, it's not a full lie, but I'm going to call it a half truth. Okay, these laws do exist, and some of you may be familiar with them. You know, that essentially it's kind of a Good Samaritan type of concept, right? If you are a volunteer serving on a nonprofit board trying to help others, you may have some protection, depending on the jurisdiction, of whether your damages can even be found against you, or they could be potentially limited in terms of what you would have to pay. And that's true. Some states still have these laws. It varies quite a bit. But what I've found to be a constant is these laws never will pay for your defense costs. You can still get sued. The law doesn't stop you from being sued. The suit's still going to be filed. You're still at a minimum going to have to pay somebody to help defend and get rid of it. It typically does not cover the corporate entity itself. So again, that does provide some limited protection to the individuals, but it may not cover the entity itself, which a management liability policy most certainly will. And it also typically does not cover any employee who is paid. So many executive directors, any paid employees, those folks are not going to be able to seek defense under a charitable immunity law. And I have over the years just heard time and time again, usually from the client, you know, to one of our agents like Brown and Brown, you know, where they'll say, well, I don't know, I don't need that because this state has X law that helps protect me, right? But that's really only half true. It's not fully correct. The second one is another misconception I see quite a bit, is organizations who don't have paid employees. So we're just a group of volunteers cleaning up the park on the weekends, do not need employment practices liability coverage. This one's an outright lie. They might not have as much exposure as an organization that has 20, 30, or 40 employees, but in the nonprofit world, volunteers, interns, and third parties, who's anyone else you deal with who is not an employee, can most certainly and will sue for sexual harassment. They could sue for discrimination, and the damages that they're going to be seeking might not be their salary, which a typical employee would sue for, but they're going to sue for emotional distress, for mental anguish, and things along those lines. I had an organization out in the Chicago area, just general kind of community organization. One of the things that they did, one of the programs they had, was a farmer's market. Chicago gets very, very cold in the winter, as many of you know. So in the winter months, they would host the farmer's market indoors. There was a gentleman who had a service animal for post-traumatic stress. He was a veteran. He attempted to enter the farmer's market with his service animal. The executive director would not grant him entry because they had a rule that no animals were allowed inside because it was a food service, facility. He was trying to enforce his rule. He did not understand that under the Americans with Disabilities Act, these animals have certain rights and can enter places that other animals cannot. He turned away the individual. They got into a little bit of a verbal exchange at the time. And that person turned around and sued for emotional distress, mental anguish, third-party discrimination, discriminating against me because of my disability. And that claim, it wasn't a massive claim, but it was a $40,000 or $50,000 payout, I believe, at the end of the day. For a small community-based nonprofit, that's a big deal if that was an uninsured loss. Fortunately, they had the right coverage at hand. But I have seen, this is probably the biggest misconception I've seen in my time of working with nonprofits. And I get the logic, right? Employment practices liability. I don't have employees. I get that. But it's all these other folks, the volunteers, interns, and third parties, 100%. And last one here, coverage for nonprofits has never been broader or more affordable. This is 100% a truth. So, the insurance market has been kind of crazy over the past 4 years. The D&O market in the public company space and the private company space has certainly seen some astronomical increases. Certain pockets in the nonprofit world has, but by and large, nonprofit organizations can get management liability coverage very, very inexpensively. We start in the 400s. We write accounts up to $40,000, $50,000. It just depends on the size of the organization, what they're doing, what their services look like, how much money's flowing through, and how many employees they have. But it's a very, very competitive market, which is good for you all as the nonprofit buyers, in that the insurance companies have all over the years made their policies broader and broader, meaning we're covering more and more things that may not have been covered in the past, or there's fewer exclusions than there may have been in policies in the past. And again, even putting that stuff aside, the defense costs alone is well worth the premiums that you're looking at there. So I do want to make sure we have plenty of time for questions, so I'll try to be brief with these last few here. But a couple of things I did just want to touch on. I spoke a little about Side A at the beginning of the presentation. As you're looking at policies, look for that. It's going to be included in a standard D&O policy. A lot of carriers might offer or allow you to purchase an additional Side A limit. So again, this is the claim that's naming you, where your personal assets are at stake. We actually include an extra $1 million for those types of claims within our base form. Third-party employment practices, most carriers are going to offer this or include it. These are your claims with like members at a club, anyone outside of an employee. Right. So this could be customers if it's some sort of thrift store or farmer's market situation. It could be, outside folks who are helping out at an event. Anybody who's not a standard employee or volunteer of your organization should be included. We talked about wage and hour a good bit earlier on, so I'll leave that there. The lifetime occurrence reporting provision is one that is a little unique to us. I think there's maybe a couple other carriers out there who offer something, but this is essentially a lifetime tail cover, we call it. So say we were all on a board together and I moved away to Florida and retired, right? And you all kept on the board making your series of decisions. D&O and management liability is what's called a claims made coverage, which means the policy that's in force on the day the lawsuit is filed is the policy that's going to respond. Okay, so it's different than a property policy where the policy in force the day the rock falls on the roof is going to respond, right? But ours is the day the lawsuit's filed. So if I move to Florida and all of you, for whatever reason, forgot to make a payment, canceled the coverage, let it lapse for whatever reason. Now, Darren would never let you do this, but if that were to happen and there was no coverage in force and a lawsuit were to be filed, this lifetime occurrence provision would actually allow me, as the innocent party who moved away, to report back to that USLI policy for the rest of my life. It's a peace of mind concept. We're trying to add in things here that will help people who are serving rest easy, knowing that they're going to have proper coverage, even in the event that the people who follow them may not maintain what they need to maintain. And pricing, like I said, starts as low as in the $400. It really depends on the risk, on the services, on the size, but it can be very, very, very inexpensive. So lastly, I just want to touch on a couple of claims. I have thousands of these, but I'll go with these two real quick. These are two of my quote unquote favorites to tell, not to think about how much was paid out necessarily. First one here, the club. This was actually, this is my story for no matter how small or simple the operations are, the claim can be very large. We insured, this was actually a bridge club down in the South. And one day they were having a bridge tournament. One of the individuals had been drinking. He was being very, very belligerent. He was bullying other players. He was using a lot of profanity. This is a small membership, not-for-profit, so obviously these folks weren't really going out into the community, interacting with the public. After several warnings, the individual was actually removed from the tournament and was set up to come see the club's disciplinary review board. Now, this group was very well run, and they had in their bylaws that if you had a behavioral offense at a club event, you got a 2-week suspension from club play. They brought him into the hearing. They gave him the 2-week suspension. He started screaming at the board and going completely nuts. The board had a, visceral human reaction to that. They got into a large argument, and ultimately the president of the board removed the person's membership permanently. They said, "You're banned from the club for life. We'll see you. Don't ever come back." Problem is, they didn't have the power to do that. This person was a retired Manhattan litigator. He's a very talented litigator who had retired to the area. He pulled the club's bylaws. He immediately identified that provision. He filed suit seeking his reinstatement to the club, which was granted almost immediately. But he decided to teach them a lesson or two, so he continued to file a sequence of lawsuits, including, slander, defamation, violation of his First Amendment rights to free speech. And he also alleged at the end of this sequence that his life's work as a retired multimillionaire attorney was a bridge strategy guide that he had been working on. And because of his untimely suspension from the club, he was unable to complete the necessary research needed to meet his publishing deadline. And because he missed his publishing deadline, he lost out on $300,000 of potential book sales. He brought half of a book too. So I don't know where he grabbed it, but he did have it with him. Moral of the story here is this was a very low minimum premium account. I think it was $500 or $600. That claim in total dragged on for about 4.5 years and cost about $800,000 in defense and settlement, all because somebody was drinking a little too much at a bridge tournament. Now, depending on the operations of your risk, obviously, those dynamics can change, but the point is, all it takes is one person, one bad event, one personality conflict that can really set off a sequence of events. This last one is more of a side A example. I talked about these side A claims. We had a group that was set up essentially to organize a neighborhood block party. So that's all it was. It wasn't even a homeowners association, but it was a group of homeowners who put on this party for the community. It was open to other folks in the community, and they just had a nice time every year. This neighborhood was next to a parcel of woods that was one day purchased by a developer. This developer wanted to bulldoze the woods and build townhouses. All our insured did really was show up to town hall meetings, write letters to local representatives, the zoning board, sharing their concerns about this potential development. And this could happen to anyone, right? Anyone in your backyard or next door to you. They didn't want the traffic, they didn't want the construction, they didn't want the noise. They were worried about property values. A few years goes by, This organization has no authority over this whatsoever. They were simply speaking their minds. The development was blocked. The developer turns around and sues everybody. He names the organization. He names our executive director personally and somebody else on the board, as well as a dozen other folks. It got really, really bad to the point that they actually used up their policy limit in terms of defense because there were some personal conflicts between the head of our nonprofit organization and the developer. They had some history together. And essentially, the organization ended up filing for bankruptcy protection as part of the litigation. And at the time that they did so, this person was still being named personally in the lawsuit, with the demand being his house. It was a $950,000 house. It was a very spiteful, angry claim. The developer was furious with these people. He felt that they cost them a lot of money, and he was intent on making them pay. And this poor person who ended up getting tied up in this litigation, was only done so by virtue of volunteering to organize his community's block party event. I don't think he ever stopped to think that something so catastrophic could happen. Now, these are not your everyday claims. These are kind of your outliers. But again, my message is that it's very, very difficult. We know the EPL claims are frequent. We know the mismanagement of funds or the failure to adhere to the mission claims are going to show up. But there's these other ones that just fall out of the sky, even if operations are pretty simple, pretty straightforward, and might not at face value seem to have a lot to worry about. So those are cautionary tales. Again, I'm not trying to make it all doom and gloom or anything like that, but it really is eye-opening with some of the dollar values we see over such seemingly minor things. Just to give a little list of some of the different types of things we write here at USLI, obviously Darren and his team would have access to far more than this, depending on what your organization does, but this is kind of a snapshot of the worlds that we deal in. The social and human service world is by far our largest segment, I would say. Community groups, people helping people. We do a good bit in the education, religious worlds as well as business organizations, trade groups, membership clubs, you name it. We're pretty broad reaching in terms of the D&O and management liability side. This next slide, I'm getting pulled into the thick of youth sports as we gear up for youth sports seasons here as well. It's just a quick snapshot through there. Again, I want to make sure we have some time for questions. Just the last thing I did want to touch on is if you do end up at any point or have currently a USLI policy, and with any carrier really, you want to be looking at some of the value-added services that carrier might provide to you, because they really can be almost as valuable financially as the insurance itself. One of the big ones I just want to mention here, Human Resources Hotline. So we have a phone number that you can call if you don't have a dedicated HR professional within the organization. A lot of times, folks are kind of doing it all. You can call and ask them questions about, how do I deal with maternity leave? How do I deal with, FMLA? How do I deal with these laws? What can I say? What can I say? What am I allowed to ask? What am I not allowed to ask? It's a free service, general anonymous information. Just so you can help make informed decisions. And then the other one I wanted to mention is discounted background checks. A lot of organizations will provide this, through different metrics, especially with very volunteer heavy organizations that might be processing quite a few of them. Those are the types of things that you may be able to get either from your carrier, or elsewhere within that vortex. And that's really all I had in terms of the presentation for today. Like I said, I'm certainly happy to answer any questions anyone had. If you have any questions and you want to throw them in the chat, feel free. Let me pull up Darren's information for you as well. And like we said at the beginning, if you have questions about your insurance, if you're looking for coverage, you're looking for anything along those lines, here's Darren's information again. I believe it was dropped in the chat a little earlier. You can certainly reach out to him and his team, and they'll be sure to get you whatever you need there. Did get one question. Do you typically have to buy these coverages together? You don't typically have to. Most of the time you're able to get, just the directors and officers, just the employment practices, but it is helpful to have them all together with one carrier, because sometimes it can be dicey if you're dealing with one insurance carrier over here and another one over here. It's just much easier if you have one point of focus to handle a claim, and typically is a little more streamlined. So no, they don't have to necessarily all be purchased together, but most of the time it makes financial sense and practical sense to do so.
Hello, can I ask a question without typing?
Of course, yeah.
Yes, it's too much to type.
No, that's fine. Go ahead.
So you mentioned the fiduciary liability. One thing we will worry about is the pension termination for our organization. We plan to, it's our plan to file IRS approval, but the time is so slow, so we decide to move forward without. So if something, the Mutual of America, the bank, did some calculation that was wrong, and who's responsible?
Well, that's often the $1 million question. So, to determine that would really end up lying within the court in terms of who's responsible. With fiduciary liability, the way those claims typically play out is they're typically going to name everybody. They're typically going to come against the actual provider, in this case, the bank, but they'll usually name the board as well. I can't guarantee that, obviously, just because the attorneys know that the more people they kind of tie into the lawsuit, the more likely they are to hit the correct person that's going to get their client the payout they're looking for. So that's kind of back to my point, is even if the actual error is made by an outside firm, it's not going to prevent the board from being potentially dragged into it, at least for defense costs in terms of settling out that liability. Does that make sense? So I can't tell you exactly whose fault it would be deemed to be by the court. That would depend on 1,000 different factors. But even if the underlying wrongful act itself was committed by an outside party, I've seen boards get pulled into problems where they might just be guilty by association or negligent in the screening or vetting of those providers. It's certainly possible.
So the actuary make the calculation. Of course, that's their profession. If
Sure.
the board, and we're looking at it, that all those numbers make no sense to us, of
Right.
course. So there's no way for us to judge. So we tried everything we could and say, the process, we can only make the process right. So one of the process we worried is we're supposed to wait for IRS, but we couldn't, because that will put us on very bad financial restraint. So we don't want to wait. We cannot afford to wait for that. And then in case, okay, so then besides the numbers are wrong. So if we closed, okay, we were trying to close the pension. Did I mention that earlier? So if everything's on schedule, we could terminate before the end of this year. So after this year, and if the organization decide we're gonna close, so then IRS approval, review come back and then find something's not right. And then, but if that time the organization is closed, what would happen? So would the coverage still cover? I think we probably have coverage. I'm not sure. It's very unclear.
It's very hard to say, and I would hate to speak on a specific live situation, because that's all going to come down to your specific policy, the wording and exclusions within that policy, and the fact pattern that's laid out if a lawsuit is filed. Now, in what you said, if there is some sort of issue, there still might not be a claim at that point. right? They might send you a letter back saying, hey, here's the issue. But that may not necessarily be a claim seeking damages by somebody who was wronged by that decision. So, I'm sorry, I'm not trying to evade the
No.
question. It's just with claims, it comes down to hypothetical claims in the D&O world are very difficult because the timing, the specifics of the policy language, the specifics of how everything played out, and then who's been damaged, right? Who's seeking something as a result? That's what's going to trigger the claim itself. So there would be too many variables for me to really effectively give you an answer.
So if we wanted to prevent, we want to have this coverage, what kind of language? So we are trying to find a deal and what is that called? D&O coverage, right?
So
is there a way to make our coverage to cover the potential risk?
That would be a discussion to have with your agent, with an insurance agent like Brown & Brown or an agency like that. Because we personally as a company, we don't write defined benefit plans, pension plans, or defined benefit plans for fiduciary liability coverage. So that's not a world in terms of the nuts and bolts of the pension plan that I typically work on every day, but there most certainly are carriers who do. It would just be, through a different company, but we typically are writing organizations using other types of plans, not defined benefit or pension plans, because those are considered a little bit higher risk within the fiduciary liability world, kind of for some of the reasons that you're outlining in terms of the liability growing to be too large.
Thank you.
You're welcome. I'm sorry I couldn't entirely answer, but hopefully that was somewhat helpful.
So we could contact Darren, I guess, afterwards, right? If we want to go for the discussion.
Sure. Yeah, absolutely. And also you want to reach out to the agent that currently insures your organization as well.
Any other questions? Thank you for that one.
Just to answer one other question I see in the chat, the
Sure.
PowerPoint slides and the recording of today's session will be sent to everyone this afternoon or tomorrow.
Okay. Well, that's all I had for today. Thank you all so much for taking some time out to spend with us. Hopefully it was a valuable use of time for you.
Yeah,
Thank you all for coming.
Thanks, Chris, for putting on a great presentation, and thanks everyone for joining. My contact information is there. If you have any questions, follow up, feel free to give me a call, shoot me an email. Happy to answer any other follow-up questions.
Thank you, everyone. Appreciate it.
Fantastic. Thanks again.
Thank you.